guys explain those Badlands? That's a hell of a name.
Good evening and welcome to the No Treason Podcast, episode 17. It's already been talked about in the chat. That's comms. And it's comms for we're live tonight. Again, I should be able to be live a good amount this month because I am working. I do a month of days and then a month of nights. And when I'm on days, I can do the show live pretty much every weekend unless something else changes. So Matt, we are live indeed. I'm your host, Jonathan Drake. Welcome everybody. Hope everyone's staying warm. We had a heat wave today. We got up into the 20s. It was quite nice. It's almost t-shirt weather considering the single digits and below zero that we've been having here in central Illinois. And I'm a little discombobulated because I rushed home. We were over at a friend's house this evening for dinner, and then the mother of the family, she's a good friend of my wife's, and she's one of the directors of the homeschool theater group that my kids got involved in the last couple of years. And back in October, they did a production of Mary Poppins, and it was incredibly well done. It's impressive to me watching 60 high school and younger children being herded like cats I've watched a couple of the early practices, and it's hilarious watching all these kids learning all their spots, and there's some really good vocal talent and a lot of fun comedic talent and rapport between some of the pairings. So that was back in October. And it was filmed, and the husband of the family put together a DVD of it. So we were over at their house watching it. I had to leave early, but rushed home to get things all put together. And so we're down to the wire here, but we're live here tonight. Good to see everyone in the chat. I see Matt Trump is here tonight. Good to see you, brother. And we got Beth and S. Heisler. We've got Eleanor. We got Matt, Lizzie Boston, Claire. All the usual suspects. Rodent Dung, hey, good to see you. Early raid from Viva, yeah. I've been fortunate that his show lines up with my show, so he's been kind enough to raid Badlands. I don't think he quite understands what's going on in this show. He might not raid otherwise, but EC was here. Good to see you, brother. All right, so let's get right on into it. Last week. Hey, Funky Pam, good to see you. We're live tonight. Last week, we examined English law, the English law precedent that from ancient times, juries were courts of conscience, meaning they judged a case based on their own sensibilities, that is, the jury, of what is or isn't just. And Lysander Spooner, in his essay, Natural Law, the Science of Justice, explains very thoroughly how such a thing is even possible. And he puts that into practice here in his essay that we're going through, Trial by Jury. We looked at the resurrection of the 100 court, which was a type of one of the types of courts that existed in the Anglo-Saxon era and carried on through into the Norman era. It was kind of lost over the centuries, but then it was resurrected in Middlesex County in the 1700s, and William Blackstone highlighted that, showing how it was a response to a court created by Parliament to try to deal with like small petty, small claims type stuff. And the one that Parliament came up with, even though it was by conscience, it was an appointed, essentially an appointed bureaucracy that ended up causing all kinds of problems. And so Middlesex County, in response to that, brought back the old 100 court style, and its juries were judging by conscience. And even though obviously that doesn't go, that's only dating to the 1700s, they did it and they demonstrated that they had an awareness that that's how the courts had been at one point. And so it wasn't the arbitrary law of kings that governed or provided the judgments, for the juries. It was their own God-given consciences. And I've mentioned many times, and I will again, that that's possible even more than the rationale that Spooner gives in his other writings, as well as here in this essay. It's possible because, as the Apostle Paul says, the law of God is written on all of our hearts. So we are born with the ability to learn and understand and know the basics of good and evil. We understand the basics of what is right and what is wrong. And so a jury can then bring that to their judgments. And we don't need to have an arbitrary fiat statute system to tell us what is or isn't right or wrong. To that point, I showed this quote last week that Spooner writes, "The principle of the jury was, therefore, not confined to its mere application as a mode of trying contested facts, whether in civil or criminal cases. And both in its form and in its consequences, it had a very material influence upon the general constitution of the realm." And how true that is. A people conducting a running commentary on law by means of a conscience-led jury would indeed have a material influence on the general constitution of the realm. Sawed this. Yep, we're live. Good to see you, George and Nana. Polymath, good to see you made it. John Harold recently highlighted Trump's comments regarding the fraud in Minnesota being at least twice of what it's reported. And then if you multiply that by the 50 states, it's a fair statement to say that the vast majority of federal expenditures are fraudulent, even beyond the fact that they're via taxation, which is obviously a fraud in of itself. And then, of course, the question that you ask about that is, what then is just about paying taxes? A jury judging by the law, by their own sensibilities and their own consciences, would be and could be the legal stopgap against such fraud by acquitting any who refused to pay a tax into a fraudulent system. And thus they empower everyone to exercise their natural right to resist tyranny without any fear of legal backlash. Currently, it's more complicated than as simple as that sounds. It's more complicated than that as far as the layers of obfuscation that have been coded on top of the natural law layer. But if you want to, get your blood boiling, just look into how difficult it actually is if you're in a situation where you're being brought up on tax fraud or tax, evasion, how difficult it actually is to get in front of a jury. I did a little digging on that this past week, and it's infuriating. But the having a jury be able to adjudicate situations like that is a clear goal to aspire to. And if we're going to put any energy into demanding anything of our government or of our fellow men, then I believe this is better worth our while than just voting harder. And why is that? It's not an uncommon phrase here on Badlands, but that's because elections are fake. Even if somehow it was possible to guarantee full transparency and get actual consent by means of the ballot, which is something Spooner argues isn't possible. And I mentioned last week, you can go back to episode 2 of this podcast, wherein I go through the 10 compelling reasons why he makes such a case. But even if it was possible to get consent by ballot, periodic elections require that we must endure tyranny for years before anything can actually be done about it. And given that it is reasonable to assume that the evil forces that were capable of either manipulating elections to install their agent in the first place, or paying enough or blackmailing enough to co-opt the elected official once they won a presumed free and fair election, those evil forces are therefore capable of doing it again after the next election if they could do it in the first one. So given that, then it is evident that relief from tyranny is not really able to be gained politically. This isn't dooming. I would ask, is it dooming to realize that the shadows on the wall are an illusion, and then turning to the people next to you and then trying to wake them up to the illusion? Or is it dooming to just sit there and pretend, for the sake of waking up the normies or some other reason, that the shadows on the wall are relevant and parsing through all the details of their movements? Not to mention that observable government history shows that the incoming government very rarely undoes the damage done by the one it replaced. So if your liberty has been assaulted, your property or your money or other things have been seized, and thus you've been tyrannized and you're seeking appropriate redress, you'll never get it, given the ease of manipulating elections or the ease of manipulating elected officials. And you can't go after the outgoing congressmen or senators because the courts protect the speech and debate clause with the utmost tenacity. You'll forgive the analogy, but this is basically like if you had been raped by a teacher, you weren't allowed to stop going to their class, and when you tried to speak to the school administration about bringing legal charges, they tell you that the teacher's contract doesn't permit them to be prosecuted for anything they do while in their classroom. And then their answer to you is, don't worry, the teacher's contract is up in 2 years and they'll be replaced by a different teacher. Meanwhile, the teacher continues to rape you, and you have to put up with it for 2 more years and hope that the next teacher doesn't also like raping students at a school in which students aren't allowed to leave and the teachers can't be prosecuted for anything they do while in their classroom. All of that is the ease with which elections are manipulated, and the absurdity of the absolute and irresponsible power given by the speech and debate clause, is likely why all of the focus in our modern era has been placed on the sacred right of suffrage rather than the ancient right of trial by jury. Now, I've been told I need to revisit some of the concepts that help drive these points home. Elections are fake for lots of reasons, but the primary reason is because the things we are voting about are already outside the bounds of natural law. And what do I mean by that? If democracy is 2 wolves and a lamb voting on what to have for dinner, does it matter if the vote was fully transparent and the lamb can accurately verify the results of the vote if the results of the vote is that the lamb is what's for dinner? Is transparency or verifiability the only thing that makes an election legitimate? You might say, well, we're not a democracy, we're a republic. If what we're talking about when we talk about voting is to install an institution that will have absolute and irresponsible power, that is, property rights over us and our neighbors, and this power is to borrow money based on credit it receives by virtue of its promise to tax us and our children forever and kill us or jail us if we don't pay, does it really matter what you call the system if the end result is that by voting, you are narratively authorizing armed agents to steal from your neighbor against their will and violate their liberty in endless ways? Or they're doing the same to you, and then we all end up as debt slaves forever? Is that something we can truly morally vote about? In the vein of the science of peace, which is what Spooner calls natural law, is that a vote that leads to the conditions of true peace? Is it moral simply because the majority of people want it? Does the lamb have to submit to being dinner simply because more wolves voted for that result? If natural law isn't an actual standard, then we have no grounds to complain about fraud or theft or murder or any other violation of our supposed natural rights, because at the end of the day, it's just might or success that makes right. And therefore, whoever stole 2020 or any other election had just as much right as anybody to do it, and by virtue of them being successful, verified and justified their right. That is the case that Spooner makes in his Science of Justice essay, which I will be getting into at some point this year. And so to that point, if government is only moral if it governs by the consent of the governed, which I would imagine most of us here would say is true, and that's a logical conclusion from the standpoint of natural law, then the answer to the question of whether or not the lamb has to submit to the vote of the wolves, or whether the wolves have any moral right to vote about eating the lamb, is clearly no. So I will refresh your memory for what Spooner argues are the tenets of a natural law contract. We covered this a lot when we were going through the No Treason essay. And if you recall, there are 5 points to a natural law contract. The first is that consent it's got to be voluntary. The consent has to be explicit. You can't just infer someone's consent. The agreement that is being made has to be done in an honest way. What's being agreed to has to be just. And the borrowing and taxing powers of the government automatically disqualifies that point right there. And then the last is that it must be universally individual. Everyone who is bound by the contract must be given opportunity to demonstrate their consent. These are logical points because natural law, that is the science of justice, the code of conduct baked into reality itself by God that leads to human peace, is basically do unto others as you would have them do unto you. It's love your neighbor. We can all recognize that it is loving to respect the consent of our neighbors because that's exactly what we want them to do for us. It is not loving to violate their consent, to steal their property, to enslave them to debt they did not consent to. And strength in numbers doesn't change that in the least. Now, I think it's fantastic that the fraudulent behavior in Fulton County, Georgia, for instance, is being exposed in wonderful fashion. And primarily because that can go a long way towards showing more people that elections are not what we were told they are. But we're just asking for the hose again, likely in the form of the system's solution to its own systemic voter fraud, as Chris Paul is warning us all about. If we don't recognize that the problem isn't the way the voting is done, but rather that voting itself is the problem. The problem is what is being voted about isn't something any of us have the right to vote about. And if we don't realize that, then we are the wolves voting alongside the lamb about what's for dinner. So what do we do instead? We've already seen how a successful and free society can thrive for centuries in the complete absence of an electoral system. The Anglo-Saxons had a king. They didn't have a representative legislature, and yet they thrived, albeit not without some difficulties here and there. This isn't a utopian concept. It accounts for the fallen nature of man. But it thrived because the people understood what liberty actually is, and they understood how to keep it, and they kept it. And they did it well enough that echoes of their devotion ultimately gave birth to this country nearly 1,000 years later. If we resurrect trial by jury as it is actually meant to be, we have a chance of picking up where the Anglo-Saxons left off and truly making this country great again. It's not an easy task, but the difficulty of the task is not an argument against doing it. It's going to take a lot of prolific, honest conversations and increasing education. And I'm not the first to raise the hue and cry about this. Guys like Michael Bolden over at 10th Amendment Center have been doing this for many years, and there are many more that preceded him. So to that end, the goal of raising awareness and education, we've been following Spooner's historical argument and case for resurrecting that potent practice. And tonight we'll continue that by examining the oaths of jurors. I would like to get to also the oaths of judges and kings, but I think we'll have to wait for next week on that one. And the purpose of that is to see what they are actually pledging to do before God. But first, we have a few sponsors, and the first is our good friends over at Rise Attire.
What is the Sovereign Alliance? The Sovereign Alliance are a collection of leaders and countries that are aligned not in the vision for their countries, but against a vision that has been thrust upon them. I believe that the Sovereign Alliance is less a battle for something and more a battle against something. They are against globalism, collectivism. They are against the rules-based international order.
Sovereign Alliance, the latest addition to Badlands Rise merch, available now at badlandsmedia.tv/rise.
And then next up, we have Badlands Shop. Happy New Year, Badlands family. Let's kick off the golden age with unstoppable action. As your favorite Badlands show wraps up, dive right into the Badlands Shop, where we've curated top-notch sponsors and exclusive deals just for you. From premium U.S.-made health supplements and grass-fed meats to bold patriotic apparel, secure tech gear, and veteran-owned coffee, we've got everything to power your America First lifestyle and crush those New Year's resolutions. Whether it's on-air spotlights or daily essentials, shopping here is easy, smart, and impactful. Every dollar you spend fuels freedom, backing patriot entrepreneurs, family businesses, and creators who share our values. You're not just getting great gear, you're strengthening the movement that keeps Badlands Media thriving. Thank you for supporting businesses that support Badlands Media. Head over now to badlandsmedia.tv/shop or click shop on the main menu at badlandsmedia.tv. Let's make 2026 legendary. And the last ad for this evening, the latest from Soft Disclosure.
The following ad is rated M for mature. Soft Disclosure wants you to get naked this Valentine's Day with limited edition his and her bundles that save you 20% off the individual retail prices. Proprietary oil infusions, grass-finished beef tallow, goat's milk from American goats, locally grown herbs and ingredients. Soft Disclosure is putting America First fruits on your skin.
And for these sexy bundles, we've added an all-new boar's haired beard brush and a solid jade gua sha. And the reason I'm here is because Alpha doesn't know how to say these words.
Gusha. His. hers. We need a moment to calm down. Don't hide your skin. Disclose it. Get naked this Valentine's Day with Soft Disclosure. Head over to softdisclosure.com and save 20% off individual retail prices with our his and hers customizable bundles, and use promo code NAKED to save 15% off the rest of the site. These statements have not been evaluated by the FDA. Promo code does not apply to bundle discounts.
You know, someone should have been in that in that planning session that maybe could have said no or something, but I think that's hilarious. As I mentioned, we are live tonight, so good to see everybody in the chat. We've got Matt Trump in the chat, Jessica Storms in the chat. We got some Badlands royalty here. There were a number of comments I saw as I was going through that, and a lot of the questions like regarding Muslims and what their concept of natural law might be or might not be does get addressed in Spooner's essay, Natural Law, the Science of Justice. And I believe it is in the show description. Let me double check. There's a link to that essay. Is there? No, there's not. I think I mentioned that last week, and I forgot to tell Brad to put it in the description. If you go to Online Library of Liberty, that is a free resource for a lot of writers and thinkers and philosophers and anything having to do with liberty-related content. You can get free PDFs. You can download them as like ebook, so that you can download it to a Kindle reader or something to that effect. And you can get if you just search there, the Natural Law, the Science of Justice, Lysander Spooner. Yeah, I'll do that, Jessica. I'll send it to you. And it's a relatively short essay. He wrote it toward the end of his life, and it's fascinating to see when you read his stuff. Like, for instance, Trial by Jury essay was written in 1852. So 35 years later, it's Giannana, it's Natural Law, the Science of Justice. If you just search the Science of Justice, Lysander Spooner on any browser, it will invariably, the Online Library of Liberty will be one of the search results, and you can get a free PDF there. But in that essay, he breaks down his arguments that when you read from early on in his writings to there at the end of his life, the consistency of his perspectives on these things. And, that represents 30 to 40 years of him plumbing the depths of his particular, view on things. Eleanor 2000 just put it there in the chat. Thank you so much. That's awesome. Rodent Dung, I make tobacco pipes as a hobby, and for the Great American Restoration Tour events that Badlands hosts 4 times a year, the next one is coming up in Nashville, April 9th through the 12th. You get the tickets for that at badlandsmedia.tv/events. And I started doing that a number of garts ago. I'd make a Gandalf style pipe, actually a replica of the one that he smokes in the movie, and they were raffled off at garts. And I saw someone make a comment about whips, and I'm going to make another whip for Deadwood again this year, and I'm going to do it in like a Badlands color theme. I think it's going to look pretty cool. Anyway, we're talking oaths tonight. We've already seen Spooner arguing definitionally for trial by jury. What it must be it's either trial by country versus trial by government. If the jury is just a mouthpiece of the government, then you're not really having a jury of your peers. You're just having a jury of avatars of potential despots. And so being able to have commentary on the law is a definitional aspect of trial by jury. And that's a sufficient argument. It's based on the natural right to resist tyranny, which is something that is codified in the United States Constitution. Spooner combines the Second Amendment, the right to keep and bear arms, with the intention that that would be how a people could prevent tyranny. He combines the recognition of trial by jury with the Second Amendment as being two co-equal aspects of resisting tyranny. One is the peaceful means, the other is the non-peaceful insurance of those peaceful means. And that's sufficient enough as an argument, because those who would take it away from us, they like to claim that it was never really meant to be, as it has been referred to, the palladium of liberty, the security of liberty. Rodent Dunk, if you like Lord of the Rings, and you end up listening to a number of other Badlands shows, especially ones with Burning Bright as one of the hosts, you will hear references, a lot of analogies get drawn from that material. Definitely a lot of Lord of the Rings fans here at Badlands. But besides the definitional argument, Spooner also draws on historical evidence. So we started looking at that over the last couple of weeks or more. We've looked at so far trial by jury's recognition in the founding documents of this country, as well as the states. And it's important to remind you that in those documents, it was not defined, it was just recognized, which means there is a pre-existing definition that they were appealing to. And that presents problems as it has been subverted and people have tried over the years afterwards to redefine it and change it. And that's what we're living under. That's what Spooner was living under. That's what prompted him to write this essay in the first place. We've also looked then at what the founders drew on for that pre-existing definition, the English Magna Carta. We've looked at how the Anglo-Saxon era's weakness of regal authority, what has been preserved in a lot of their legal documents from that era and contemporary writings describing how the kings really didn't have a total control over the legislative power, because the jury would be able to resist them. And then last week, we looked at how the ancient courts, the juries, were courts of conscience and not just regurgitating whatever law had been passed. Which really makes sense, because what is a law? How did something become a law? Does it become a law? Or rather, is it something that is discovered as law? And that's a significant distinction that we'll talk about more before we're through with this essay, because Spooner likes to drive that point home. The science of justice alludes to the idea that it's something that can be discovered and studied and learned. And that will be brought out more when I again encourage you to read the essay, The Science of Justice, but I will be going through that as well, which I enjoy doing that, because when you read something with a mind of turning around and trying to teach it, it really helps to solidify those things in your mind. And I've very much enjoyed doing that with trial by jury and no treason. And I'm reading through another of his essays I've mentioned before called Poverty, Its Illegal Cause, and Its Legal Cure. And there's a lot of really fascinating concepts that he brings up in there, all tying together his basic understanding of natural law and then just plumbing its depths and finding what he can in there. So tonight we're going to continue the history lesson by examining the oaths that were administered to all the parties involved in the administration of justice in the history of English law. There's three categories. I mentioned them already. It's the juries, the judges, and the king. Tonight, we'll just have time to get to the juries. And I'll start by saying first and foremost that if you recall any discussion from, this was back in episode 6, oaths are meaningless. Spooner calls them idle wind. But in this case, they are useful in that as they had been recorded, they record what the expectations were, what the colloquial understanding was for the rights and responsibilities of all of those parties that were involved in the administration of justice. So to that end, section 3, we're in chapter 3, or chapter 2. My mind is drawing a blank. It's easy to look up in the table of contents. But we're looking at the oaths of jurors, and we'll begin with Spooner's quote here. The oaths that have been administered to jurors in England and which are their legal guide to their duty, all, so far as I've ascertained them, corroborate the idea that the jurors are to try all cases on their intrinsic merits, independently of any laws that they deem unjust or oppressive. It is probable that an oath was never administered to a jury in England, either in a civil or criminal case, to try it according to law. And how can this be? Because we are all under a higher law, and we all intrinsically know basic justice. We all intrinsically, through our consciences, can tap into that higher law, and no one is above the law. If there's a matter that is difficult to ascertain what the law in a particular case should be, and there's a lot of confusion, and you can't even get 12 people to agree that it should be a law, chances are it shouldn't be a law. There goes out probably 90% of the activity of the courts of today. If natural law is simply to live honestly, as Spooner asserts, then it's pretty easy to figure out whether or not that law has been violated. You could just run through that list I mentioned earlier, the 5 points of a natural law contract. Was someone's consent violated? Was the contract honest? Or was there an honest mistake that was made? Or was someone intentionally defrauding someone else? Was the action undertaken, was the action that was contracted to, was it just? It's not a natural law abiding contract to engage, to contract to engage in violating, someone else's natural rights. Was everyone involved explicitly consenting? Was there property that was lost or damaged or stolen? That's pretty easy to figure out. And when you start thinking through this process, you realize, I've mentioned this before, no one knows how many laws are on the books today. And that's kind of almost a joke at this point. In a natural law society where people are taking ownership of the administration of justice, you can pretty well figure out and understand the extent of the law, because it has to do with violating people's consent, basic just activity, property destruction, property theft, etc. It's not that complicated. And that essay I've mentioned really helps to flesh a lot of that out. And later on in this essay, in the chapter entitled Objections, we'll get into some of his arguments about that. The earliest oath that I have found, this is Spooner, I have found prescribed by law to be administered. This is Spooner quoting Blackstone, excuse me. The earliest oath that I have found prescribed by law to be administered to jurors is in the laws of Ethelred about the year 1015. So 50 years before the Norman, 51 years before the Norman conquest, which required that the jurors shall swear with their hands upon a holy thing that they will condemn no man that is innocent, nor acquit any that is guilty. Blackstone talks about grand juries and petit juries, and he says that the institution of two, that is the grand and then the petit, the grand being the later form, took place after the Norman conquest. And I would agree with a lot of people that in thinking that grand juries are a good idea, and they might represent a quality evolutionary improvement over what the Anglo-Saxons had developed, and as such, it's worth holding on to. But for a system like this to work, they're not inherently necessary. But moving on to the arguments or the recording the oaths here, we have from George Crabbe's History of English Law. Spooner quotes that by a law of Henry II in 1164, it was directed that the sheriff, and I'm not even going to try to read that Latin, it's translated, the sheriff shall make 12 legal men from the neighborhood to swear that they will make known the truth according to their conscience. So here again, we see the governing principle is by conscience, not by statute. But we can see the king, even a Norman one, fulfilling his duty as guardian of the law by ensuring that jurors be sworn to abide by their consciences. The king could have easily directed them to abide by his particular standards of justice, but maybe even at that time, this is, 100 years after the Norman conquest. So even by that time, the Norman kings recognized that the people who had not been replaced by the Normans, it was just the elites that had been replaced, as we discussed a number of episodes ago. The people would not accept such a dramatic departure from the culture that they had cherished. Spooner draws more on Blackstone. He says, it appears from Blackstone that even at this day, so mid-1700s, neither in civil nor criminal cases are jurors in England sworn to try causes according to law. He says that in civil suits, juries are, and this is quoting Blackstone, sworn well and truly to try the issue between the parties and a true verdict to give according to the evidence. And the point drawn out here is that there's no mention of being sworn to judge by the law. So this is kind of declaration of fact by omission. And Spooner comments on this because he takes issue with how Blackstone records this, because this line here that regarding the judging by evidence, he says the issue to be tried is whether A owes B anything, and if so, how much, or whether A has in his possession anything that belongs to B, or whether A has wronged B and ought to make compensation, and if so, how much. So then he goes to comment on this issue. He says, no statute passed by a legislature, simply as a legislature, can alter either of these issues in hardly any conceivable case, perhaps in none. No unjust law could ever alter them in any. They are all mere questions of natural justice, which legislatures have no power to alter, and with which they have no right to interfere, further than to provide for them having them settled by the most competent and impartial tribunal that is practicable to have, and then for having all just decisions enforced. And any tribunal, whether judge or jury, that attempts to try these issues has no more moral right to be swerved from the line of justice by the will of a legislature than by the will of any other body of men whatever. And this oath does not require or permit a jury to be so swerved. And this is the basis for judging the statute, judging the law against the standard of immutable natural law. E.H. Kyle says, man has made over 1 million laws to God's 10 original laws that say the same thing. And later on, especially in the chapter I just mentioned called Objections, he draws on that. He doesn't make that exact comparison. And basically that if it's a law that we can determine for ourselves that agrees with natural law, when a legislature makes a law that agrees with natural law, the law the legislature has made is unnecessary if it agrees with natural law. If it doesn't agree with natural law, then it's a usurpation and it's a violation. There's a quote that came across my feed that the 10th Amendment Center posted. I had never heard of this guy. His name is Algernon Sidney, and he was a champion of natural law in the 1600s and maybe early 1700s. And he wrote, that which is not just is not law, and that which is not law ought not to be obeyed. And seeing his name and then looking him up and then finding on the online Library of Liberty all of his writings. And it's a little bit difficult to read because it's even more sort of old English style, but he has a tremendous amount of writing on a lot of adjacent topics. So I have even more reading to do on my list. But and it's interesting to me that Spooner never quotes Algernon Sidney, because everything that I've read so far from Sidney is like, well, that's Spooner, that's Spooner, that's Spooner. I mean, it's pretty awesome stuff. But the goal then of any court, considering that which is not just is not law, that which is not law ought not to be obeyed, The goal of any court should be to render justice. Justice being an immutable concept, not just to agree with an arbitrary statute handed down by a group of illegitimate representatives who are unable to prove anyone actually voted for them, thanks to the secret ballot. And even if they could, by natural law, can only speak on behalf of those people who voted for them, and not on behalf of those who didn't vote for them, or for those who voted against them, or those who just didn't vote at all because they didn't like the process. In the spirit of do unto others as you would have them do unto you, which is natural law, would you feel justice was being done to you if a group of people voted amongst themselves to borrow money in your name and hadn't bothered to obtain your consent? And then if you didn't pay the interest on the loan, they would throw you in prison or kill you. This is why they are loath to allow juries to exercise their tribunal rights, which are based in the natural right to resist tyranny. And they've added many, many layers and hurdles to juries exercising those rights as they possibly can. And I left this quote up here because that which is not just is not law. But a judge is going to instruct a jury quite the opposite. And it's your responsibility, if you're ever on a jury, to be the person standing in the gap for the sake of liberty. Spooner comments, or he quotes Blackstone again. In criminal cases, Blackstone says the oath of the jury in England is well and truly to try and true deliverance make between our sovereign lord, the king, and the prisoner whom they have in charge, and a true verdict to give according to the evidence. So this is the issue. Spooner takes issue with this according to the evidence line, which I looked up a lot of the common, like the federal, the federal oaths to juries today, and they all have that line according to the evidence. Plants Heal says judges hate nullification, and I'm going to pause here for a second because a number of cases have made the news in recent months, having to do with like ICE and stuff, where the jury nullified, quote unquote. That's the term that's been used in the media, that the jury nullified and acquitted a person who was obviously guilty or whatever. That is not nullification. If the case cannot be made to the jury that the person did or did not do something that, whether it's against natural law or whether it's against some man-made statute, if the prosecution is not able to present evidence to prove to the jury that that person actually did that thing, and the jury acquits the person, that's not nullification. That's just simply the jury was not convinced beyond beyond reasonable doubt. Nullification is specifically the person did something that, and the evidence clearly demonstrates and proves it, but the jury has decided that the law itself is wrong, and then they decide to acquit the person because the law is wrong. That is nullification. Simply not being able to prove to a jury that a person did something, and that might be through, screwing up of the legal process. Ash has mentioned a number of times recently, there's a lot of really shoddy legal work that is done. I think all of us have been lied to by the TV that, there's all these high powered lawyers, all these, Law and Order type shows. And so we tend to think that, well, they're a lawyer, so therefore they must be experts. But just like someone who's wearing a white lab coat and has a stethoscope around their neck and they have the title of doctor, that doesn't mean they actually know what they're talking about. And so we sort of assume that, well, it's being presented, correctly to us. And I don't think that's the case in this situation. And then E.H. Kyle says nullification by two judges in Minnesota throughout. I'm assuming that's not threw out, but like had thrown it out, the jury's verdict. And I didn't look particular into that case. I think it was a fraud case or something. And yeah, that demonstrates a problem with our system, where essentially the judges are arrogating themselves over the natural right of people to be judged by their peers. So in commenting on this Blackstone quote, Spooner says, the issue to be tried in a criminal case is guilty and not guilty. The laws passed by a legislature can rarely, if ever, have anything to do with this issue. Guilt is an intrinsic quality of actions and can be neither created, destroyed, or changed by legislation. And no tribunal that attempts to try this issue can have any moral right to declare a man guilty for an act that is intrinsically innocent at the bidding of a legislature any more than at the bidding of anybody else. And this oath does not require or permit a jury to do so. Spooner goes on and says that in spite of still demonstrating that juries, they're not ruling by fiat law. So again, this is like declaration of a true thing by omission, of saying like Blackstone wasn't saying that they also judged by law. He doesn't say that, which indicates that was never a thing. The words, according to the evidence, and this is where Spooner is taking issue with Blackstone, have doubtless been introduced into the above oaths in modern times. They are unquestionably in violation of the common law and of Magna Carta, if by them be meant such evidence only as the government sees fit to allow to go to the jury. And this should remind you all of our discussions regarding Tina Peters. If the government can dictate the evidence and require the jury to decide according to that evidence, it necessarily dictates the conclusion to which they must arrive. In that case, the trial is really a trial by the government and not by the jury. The jury cannot try an issue unless they determine what evidence shall be admitted. The ancient oaths, it will be observed, say nothing about according to the evidence. They obviously take it for granted that the jury try the whole case, and of course, that they decide what evidence shall be admitted. It would be intrinsically an immoral and criminal act for a jury to declare a man guilty or to declare that one man owed money to another unless all the evidence were admitted, which they thought ought to be admitted for ascertaining the truth. Plants Heel says, depends on how you define intrinsically innocent in regards to Spooner's quote there about guilty or not guilty. And I'll hold off on, because we're getting long on time here. I'll hold off on an elaboration on that until I get to the Science of Justice essay, or like I said, go read that for yourself. It's not that long of an essay, but there is an intrinsic, like based in natural law, there is an intrinsic innocence, and that has been subverted in the way that we do law in our culture today. Now, regarding grand juries, Spooner writes, if jurors are bound to enforce all laws passed by the legislature, it is very remarkable fact that the oath of grand juries does not require them to be governed by the laws in finding in indictments. The English form, I did not make a slide for that. So the English form, as given in the essay on grand juries written nearly 200 years ago and supposed to have been written by Lord Somers, is as follows. So, where am I at here? Okay. So this is from Lord John Somers. He was active in the latter half of the 17th century and into the 18th. He was a key architect of the Glorious Revolution settlement of the 1680s. This was long after the English Civil War. He was born right after that. But he culminated, all that activity culminated in the English Bill of Rights, which he was deeply involved in 1689. He was intent on the rule of law over the prerogative of the king. And he wrote clearly that juries, grand and petit, were safeguards of liberty. He's referenced by numerous founding fathers and is an obvious forerunner of the ideas that Spooner fleshes out and that a lot of the founding fathers wrote about as well. And so this is the oath that he records that was required of members of a grand jury. And again, the oath means nothing. This is simply to demonstrate what it was that they culturally understood to be going on inside of a courtroom. So a grand jury member would swear, you shall diligently inquire and true presentment make of all such articles, matters, and things as shall be given you in charge, and of all other matters and things as shall come to your knowledge touching this present service. The king's counsel, your fellows, and your own, you shall keep secret. You shall present no person for hatred or malice. Neither shall you leave anyone unpresented for favor or affection, for love or gain, or any hopes thereof. But in all things you shall present the truth, the whole truth, and nothing but the truth, to the best of your knowledge. So help you God. Now, considering the fact that Somers was writing in the 1600s, that last line should be familiar to everyone. That demonstrates how old that is, because he's recording that in the 1600s, and that was what was being required of grand juries at that time, and that extended much further back than when he was writing. It's an ancient concept. He goes on, if it be asked how or in what manner the grand jury shall inquire, the answer is ready according to the best of their understandings. They only, not the judges, are sworn to search diligently to find out all treasons, etc., within their charge, and they must and ought to use their own discretion in the way and manner of their inquiry. No directions can legally be imposed upon them by any court or judges. An honest jury will thankfully accept good advice from judges as their assistants, but they are bound by their oaths to present the truth, the whole truth, and nothing but the truth to the best of their own, not the judge's knowledge. Neither can they, without breach of that oath, resign their consciences or blindly submit to the dictates of others, and therefore ought to receive or reject such advices as they judge them good or bad. Nothing can be more plain and express than the words of the oath, express than the words of the oath are to this purpose. The jurors need not search the law books, nor tumble over heaps of old records for the explanation of them. Think about how the jury process is done today in light of that quote right there. How far we've come. The line, known and understood by every man. You might think of this as a foreshadowing commentary on the burden of legalese and how the lawyer class has carved out for themselves an entire world with which you must engage, but with great effort or at great expense, since by and large most of us are unable on our own to make any sense of it. This is the direct antithesis of justice, and Lord Somers recognizes that. He says, cannot put a new sense upon them. This will become even more relevant when we discuss Spooner's objections to how juries have been subverted, and I'll present my own research to that effect as well. But we live in an era in which language itself is under assault. Common language is under assault, and any appeal to a higher standard is met with vehement censorship. It's important to remind you that trial by jury was not defined in the Constitution. And what was meant maybe as a safeguard has been exploited by a predatory judiciary by assigning its own definition and then, unfortunately, successfully trusting in the complacency of the people to ignore the judiciary's usurpations and forget our heritage. He says, impose their own opinions upon the jury. And again, think about Tina Peters. This is why I argue her case has less to do with honest elections, because such things don't exist, and more to do with the inversion of trial by jury. The judge told the jury what to think, how to think it, what they were allowed to think about, what they were allowed to consider as evidence, what they were allowed to consider as an argument, and that is an absolute usurpation of justice. Summers says to use all just and proper ways. This is an appeal to a higher standard of justice than what is claimed by a representative legislative body. This is an affirmation that justice is discovered, it's not made. Law is learned, not decreed. And it is the responsibility of the jury to do just that. And as Spooner said, certain actions compared to natural law are either guilty or not guilty, and no decree can change that. I see Unati is taking off. Good to see you in the chat. Glad you're here. There's the quote, if it be commanded by the judges. This is a striking indictment on our current legal system. It is not a justice system. It's an affront to justice to call it a justice system, because by interfering with the selection of evidence, the relevance of arguments, and many other details, the judges of courts today command juries to forsake all the natural and proper means by which their understandings suggest for the discovery of truth. Plants Heel asked, does Spooner have a remedy for corrupt judges? He does talk, there's a chapter we'll get into that. I don't recall off the top of my head exactly what he says specifically to your question, but the remedy would be, if you're on a jury, you have an opportunity to be the shining beacon and light for liberty. The Supreme Court in a case, I think it's Sparf v. SPARF, Sparf v. United States, the right of a jury to nullify a law is upheld, but they also upheld that a jury does not have to be informed of that, and also protects the actions of a judge to actively and aggressively prevent the jury from finding out about that. So the solution is what we're doing right here. Education before the fact. How far we have fallen. But we are not without tremendous resources with which to make this fight successful. We just need to keep fighting, keep going on. And as a white pill, how many of you had ever heard of anything that I've talked about since the beginning of October, going back to the No Treason essay and then into this essay? The fact that there's so many of you here, which right now we've got almost 700 people watching live. I'm not going to try to brag on view counts, but each of these episodes is getting anywhere between 30 to 50. I think the highest I've seen is 55,000 views. That's a lot of people hearing this stuff. And hopefully you guys are all talking about it with people in your lives. So that's an encouragement to me that I've mentioned before. I've been reading this stuff for the last 18 years of my life, talking about it with whoever would listen, being referred to as crazy and oh, that'll never happen. Oh, that's crazy. That's nuts. And so I'm tremendously encouraged by being able to have this platform and talk about this stuff and have you all respond so well. And I've mentioned before, and I'll say again, I've got a Telegram chat if anyone wants to go and ask questions, and I'm able to be in there fairly frequently. So we can engage that way as well. That's t.me/the No Treason Podcast. The link is in the description if you don't want to remember that. But this is an encouragement, the fact that we have so many people listening. And all of that from Lord Summers. Claire says, we are your peeps, Jay Drake. I appreciate that. You're my peeps as well. And I also, going back to Gart, I hope to see many of you there. I will be there. And please come up and say hi. It's a way I've described it before, and the way it feels when you're there, it's like you're having a long-lost family reunion with people you've never met. Now, I mentioned I thought I could get through all three oath types tonight, and that's obviously not possible. And in my show prep, I realized that as I'm scrolling through my notes, and like, man, I got a lot of stuff here. Matt VK says, I've sufficiently angered us for the evening. Good. Let's get angry. But anyway, we will next week combine judges and kings, their shorter sections. And it's the same basic concept, just reinforcing the what it was that the people understood were their responsibilities in their relevant roles. And I like nerding about this type of stuff. Like I said, I'm loving digging into this and following the different rabbit trails and stuff. And I'm happy to see everyone's here. About willing to listen and learn as well. And looking ahead, kind of zooming out, trying to gauge how to proceed, because this is an extensive essay. Like I said, it's more like a book. And I want to cover all this stuff because I think it is important to deeply understand this valuable tool and be well prepared against any and all pushback, because there is a lot, especially from the court system. So looking ahead, there is still to cover the right of juries to fix sentences, the right and duties of jurors in civil suits. I mentioned the chapter that's on objections, Spooner's commentary on how the juries of present day are illegal, how the judges are illegal. There's a section on the free administration of justice. And then he has discussions on the moral considerations for the jury, things on criminal intent. And then one I'm very much looking forward to getting into is entitled Limitations Imposed on the Majority by the Trial by Jury. And then lastly, he has in an appendix, he has a section called Taxation, which gets into exactly how does this justice system pay for itself? How did the Anglo-Saxons effect the payment for these services? But anyway, I see AOB is in the chat too. Good to see you. And thank you so much for joining me tonight and putting up with my ranting and raving and nerding out on this type of stuff. I encourage you all to head over to the narrative and harass the Brights. That's kind of our end of Sunday night activity. And I'll see you all over there, but have a good night and I'll see you next week.
Why a spoon, cousin? Why not an axe?
Because it's dull, you twit. It'll hurt more.
Thank you so much for joining us, and don't forget to hit the thumbs up on this video. And a special thank you to all of our advertising partners. Please remember to shift your dollars to support those businesses that support Badlands Media.